And welcome back to Legal Tips with Harriet, your favorite place for legal tips and advice. In today's video, we will be talking about how you can resolve conflict without going to court in Nigeria. We all know that going to court anywhere in the world can be time-consuming, expensive, and emotionally draining. So if you are dealing with a dispute, whether it is with a business partner, your landlord, or even family matters, stay with me because there are ways you can handle this conflict quickly and peacefully without going to court. I know we like saying we will meet in court, as this is often seen as a straightforward approach to resolving issues, and also it makes us look powerful. However, the question is, do we truly need to take this route and face the lengthy, often complicated court proceedings? Fortunately, there are alternative ways available that can provide more efficient and less adversarial means of resolving conflict. These approaches are collectively recognized as alternative dispute resolution, commonly referred to as ADR. This method involves a variety of techniques designed to facilitate negotiation and settlement outside the courtroom, and it allows parties to reach satisfactory agreement without the need for formal litigation. But before we proceed, have you subscribed? If you are yet to subscribe, please do so now. Alternative ways you can resolve conflict in Nigeria include, but not limited to, number one, the first method is negotiation. This is the simplest and most friendly way to resolve conflict. With negotiation, there is no fighting. You and the other party will sit down, talk it out, and try to find a solution that works for both of you. You don't need a third party. The moment you embrace negotiation, both sides must be willing to compromise and genuinely be interested in resolving the issue. There also has to be that resolve within you to keep communications clear and respectful. Bear in mind that you are partners looking for a meeting point. Once you reach an agreement, write that agreement down and have both parties sign it, and you are done. This part is very important because even if you trust the other person, having everything in writing ensures that there are no misunderstandings later. Number two, another way you can resolve dispute without going to court in Nigeria is through mediation. In mediation, it is not going to be just you and the other party. A neutral third party called the mediator is invited in to help you and the other party reach an agreement. Note the word, help you reach an agreement. This means that the mediator will not decide for you. Rather, he will guide the discussion and help you come to a mutually beneficial solution. There are professionally accredited mediators from multi-door courthouses and the Chartered Institute of Arbitrators that you can use. Is mediation agreement considered legally binding is always the question that you will hear. The answer is yes. When a mediation agreement is formally registered in a court of law, it attains the status of a binding contract. This means that it is enforceable and carries legal weight that requires the parties involved to adhere to the terms outlined in the agreement. The registration process solidifies the commitment made during mediation and ensures that both parties are accountable for fulfilling their obligations as specified in the document. Number three, another effective approach to resolving conflict without resorting to litigation is the process of arbitration. Arbitration shares similarities with mediation, but there are distinctions between the two. In arbitration, a neutral third party, known as the arbitrator, takes on a more authoritative role, unlike the mediator, who facilitates discussion and helps the parties negotiate their own resolution. The arbitrator reviews the evidence and arguments presented by each side and delivers a binding decision. The mediator guides you to take a decision yourself, but the arbitrator listens to you and takes the decision on your behalf. This means that once you choose arbitration, you have to prepare your mind to be bound by the arbitrator's decision. The arbitrator's ruling must be adhered to by all parties involved. Arbitration, compared to litigation, provide a structured yet more flexible means of dispute resolution. Arbitration is commonly used in business dispute, especially where large amount of money is involved. To make arbitration easier, and if you don't want to go through the rigorous steps of litigation, then when drafting a business contract, include an arbitration clause. This clause specifies that if a dispute arises in the transaction, it will be resolved through arbitration rather than litigation. Another plus for arbitration is that it is faster and more private than going to court. Once the arbitrator makes a decision, it can be enforced like a court judgment. Number 4, conciliation and customary arbitration. Conciliation and customary arbitrations are other alternative ways you can resolve dispute outside of traditional court systems. Conciliation involves a neutral third party known as the conciliator to facilitate the dialogue between the parties in dispute. The conciliator's role is to guide the conversation, encourage open communication, and promote understanding to arrive at a peaceful resolution. Sometimes the role of a conciliator and mediator is confusing. Mediators don't provide legal advice or impose solutions on the parties, whereas conciliators may offer suggestions and advice based on their expertise in the subject matter. They can use their expertise to guide the parties towards specific outcomes. Customary arbitration, on the other hand, is rooted in traditional practices and cultural norms. In this process, a knowledgeable, respected member of the community hears both sides of the dispute and makes a binding decision based on customary laws and local practices. So if you are dealing with a community or family-related dispute, you might consider customary arbitration, where traditional leaders or elders will help to resolve the issue based on local customs. Just make sure that the final agreement aligns with the law so as to guarantee its enforceability if things go south. Number 5. Multi-door courthouses. You have heard negotiation, mediation, arbitration, conciliation, and customary arbitration, and you are not sure which methods to use. Then visit a multi-door courthouse near you. They will guide you through the processes. The multi-door courthouse is a one-stop center for all kinds of alternative dispute resolution. Many states in Nigeria, like Lagos, Abuja, and Kano, have multi-door courthouses where you can access mediation, arbitration, and conciliation services under one roof, and they are fast and affordable. In conclusion, having a legal consultant by your side always can never be overemphasized. As a legal practitioner, I can assert that finding ways to resolve conflict without resorting to the courtroom in Nigeria represents a more astute and advantageous choice. It is a smart move. The saying, justice delayed is justice denied, connects strongly to the situation of court cases. If you wish to circumvent the unfortunate reality of this denial, it is imperative that you explore alternative dispute resolution methods. Options such as we have discussed: negotiation, mediation, arbitration, conciliation, traditional arbitration, and the innovative multi-door courthouse system not only serve to expedite the resolution process, but also provide significant savings in terms of both financial resources and emotional strain. By embracing these approaches, you can achieve more timely and satisfactory outcome. If you found this video helpful, please like the video and leave your comment. If you are yet to subscribe to the channel, please do so now and share it with someone who might need this information. Thanks for watching. Until our next video, remain blessed.